dear audience, welcome to 2021 World Intellectual Property Forum, the online virtual conference. I'm the moderator, Professor Mei-Hsin Wang from National University of Science and Technology, Taiwan. I'm the Fellow Royal Society of Chemistry, UK. I'm here for the panel titled Controversy and Friend for Standard Essential Patenting Codes. In this panel, we are very honored to have Sir Christopher Voit, the former Law Justice Appeal, UK Court Appeal, England Wales, Honorary Professor of Law from University College London, and Professor Randall Rader, the former Chief Judge of United States Court of Appeal for the Federal Circuit and the Rader Group. Professor George Thomas Voit, the Presiding Judge of Germany Federal Patent Court, and Dr. Joseph Kim, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Offices, to share their views on the panel titled Controversy and Friend for Standard Essential Patenting Code. Our speaker is Professor Thomas Voit from Germany Federal Patent Court. Your Honor, would you mind kindly share your view on SEP and FRAND in Germany?
Thank you, Professor Wang. And good day for you, ladies and gentlemen. And I'm very honored to speak to you. As I suppose you all know about the SEP problem, or what a SEP is, I will jump pretty direct into the medias in res in Latin. So in the middle of the problem, on the one hand, we have an increasing number of standards nowadays, for example, in the automobile industry, or in the telecommunication industry, or in the IT industry, because there are global markets, and you have to comply with standards wherever you are. On the other hand, there is an increasing number of patent granting. So, for example, we had an increase of 7% from 2018 to 2019. If you look at the WIPO statistics. So, the next slide, please. And if you look at the SEPs, on first sight, SEPs are a good investment for the owner of the SEP, because everyone has to comply, and therefore everyone needs a license for your patent. There were less problems as long manufacturing companies owned the SEPs, because this was some kind of a closed shop, which means if one company had an SEP, the other company who wanted a license, then they made an agreement like a cross-licensing or anything else, and therefore there weren't many problems. But about 10 years or a little more, 15 years ago or so, most companies sold parts of their company, and it was called concentration on core competences, and therefore a lot of SEPs appeared on the market, and a lot of companies bought the SEPs and are now on the way to make money with the SEPs. Please, the next slide. And if you look at the antitrust law, SEPs are always a problem because you have some sort of monopoly on the one hand, and on the other hand, with the standard, you can impede the technical progress, also the fair competition. Therefore, some organizations like the ETSI in Europe or the ITU made agreements like FRAND, which means fair, reasonable, and non-discriminatory. And therefore, they had developed some agreement positions. Next slide, please. And I want to give you some examples because from the beginning the jurisdiction tried to apply the FRAND regulations, and we had our first decision in Germany was the Orange Book standard, which means some standards handling with CDs, compact discs or DVDs. And therefore, our Federal Court of Justice made some points or stressed out some points. And the second important decision in Europe was the decision of the Court of Justice of the European Union. It's called the Huawei versus ZTE case, which took place on July 16, 2015. Next slide, please. And both the Federal Court of Justice in Germany as well as the Court of Justice in the European Union that there could be an abuse of a dominant position if the patentee prevents others from access to the market, at least if the patentee has agreed before in the FRAND regulations. And so the Court of Justice of the European Union stated you have to get a license if you make an offer to the patentee, but the Court of Justice of the European Union also said you have to make an offer to the normal condition, which is usual to get a license. So this always had been a problem because nobody knows the normal standard for a license. Nobody knows how much percent of the price you have to offer. And so a lot of courts said we can't work with this things made by the Court of Justice of the European Union. And therefore, there was a new decision last year. Our Federal Court of Justice made a decision. And here it said that a dominant patentee could apply for an injunctive relief, also for destruction claims or recall, if the competitor don't make any efforts for gaining a license. This case was called Ziswell versus Hire. And in the same decision, the Federal Court of Justice went back to regulation in the German law, which is called, or which is Article 315 of our Civil Code, wherein is stated that you only need to make an offer without any need for telling an amount of the license fee. You only have to offer, I want to get a license, and then the court can decide about the license fee. So that's a little bit new, because you don't need to make a real or offer a real number for the royalty. You only need to offer, I want to get a license, and I agree with a license fee for that, but the height of the license fee will be decided by the court, and the court has to decide with seeing all circumstances, and so you can be pretty sure not to get a too high license fee, but also not too low a license fee. But another point of view in the decision Ziswell versus Hire is that the Federal Court of Justice also said even if a patentee is a dominant patentee, it can also use all enforcement for its patent, and also can bring the license-seeking company out of the market. So it's on the one hand an enforcement of the position of the patentee, and on the other hand little relevation for the license-seeking company. So it's a pretty Solomonic decision in my point of view. But some people say there is an over-enforcement of the patent, but I don't think so at the moment, to be honest. Please, the next slide. Yeah. The case dealt with a part of the GRPS standard, also, but it's a part of the mobile communication standards. You may know it's a general radio packet standard, and therefore, if you're dealing with mobile communication, you know there are a lot of standards on the market or in the wild, I would say. And there is always the problem to deal with the abuse of the dominant position on the one hand, protection of the market, of the free market on the other hand, and therefore the Federal Court of Justice wrote a long decision, about 30 pages, I think, and the only preposition was in this case that the license-seeking company was not willing a license because first it did not answer within a period of more than a year upon the patentee's request to get a license. And in addition to that, the court did not see a serious license offer by the potential licensee. And therefore, the Federal Court of Justice stated higher demands than the Court of Justice of the European Union, but that's only for this case, in my point of view. And on the other hand, you have to respect the Article 315 procedure, which means that you have only to offer, I want to get a license, but the royalty should be decided by the court. And some people in the literature that, oh, the Federal Court of Justice had here a patent over enforcement, but I don't think so. I think it's a quite wise decision by the Federal Court. Please, the next slide. Naturally, there is a difference between FRAND cases and nullity cases concerning SEP, because FRAND is part of antitrust law, and in nullity cases, there only the validity of the patent is the base of the decision, no matter if it's a SEP or not. If you're dealing with FRAND agreements, I think also the FRAND agreement is a quite wise decision, because it's the only way to comply with antitrust legislation, because you need something to hold the market free from a monopoly, which is a pretty important thing. Another problem with the SEPs nowadays, as I mentioned before, is because there are a lot of NPEs now on the market, and NPEs normally are not very interested very much in a settlement, and therefore you have to go along always with a dispute, really dispute, or a real dispute, because the NPEs only want to get commercial exploitation of the patent, and not like it was before, only to go along with your competitor and get some other advantages from your SEP, for example, a license for another procedure or another thing, like it was before, as long as it was a closed shop between the companies on the market. So I think the problem is more that a lot of SEPs are used to gain money only, and not to solve the problem with economic consciousness, I would say. Yeah, and that's unfortunately a thing which came from the big companies mostly, because they sold a lot of SEPs also to get money from the market. Yeah, that was my presentation, and I thank you for your attention very much. And we can start the discussion or the interview if you want, Mei-Hsin.
Thank you very much for your honor. Give us very comprehensive true case and issues, how to deal with the royalties and validities as well, because in the business world, price to reflect with the quantity sometimes is reasonable, but the licensor always insists they comply with FRAND, but however, there are lack of information equivalence. So the licensee feel otherwise. Therefore, everybody rush into the court to seek for the justice and to make the judge very busy and have to consider all the statistics, all circumstances to decide what would be the reasonable royalties. Currently, regarding the validity, we are aware your core are very specialized in the validity issues. We were just wondering, because nowadays people, they tend to use AI to help to identify whether the patent is valid, or whether the patent are the true essential standard patents. For example, in the United States, they have the TCL case and Ericsson case. They use a software they involve to analyze the patent. So I wonder, is there any fashion in Europe how you could identify the true validity of essential standard patents? Because in old days, they always have independent experts. So what would be the trendy fashion so far in Europe?
I think the simplest way would be if you look at the real standard, and if the patent itself covers a part of a standard, then you can assume that you have a SEP. And mostly the patentees will make the standard as a part of the suing, because they say that's a standard which is from the meeting so and so, and mostly you have the protocol of the meetings where you can see okay, there was the beginning, then the company A brought in this argument, and the company B came with this argument, and then mostly 6 months or later the standard was fixed, and then you can see, okay, I know that's an SEP. So that's the most usual way. Sometimes you can't see really a standard essential patent because the parties don't say that's a standard essential patent. Because if you come with a standard essential patent to the court, the court fee will be higher than it's a normal patent without the character of an SEP. But mostly one of the parties say, okay, that's a part of the standard. And I never experienced a case where not one of the parties wrote in the protocols of the meeting. So mostly, you know, that's a part of the standard.
Thank you very much. Thank you. Thank you very much.
Question? Yeah.
Yes,
okay.
yes. It's very very meaningful for people how to learn whether they should disclose their patents essential standard patent, because the fee will be different, and how we can refer all the protocols from the IEEE or SSOs to learn to identify whether the patent is indeed a SEP. So thank you very much for your very comprehensive explanation and sharing all the cases and the rule, principle, protocols in Europe.